Hello, friends. I welcome you all to this session of Indian Evidence Act. And today we will be studying Section 141, Section 142, and Section 143. These three are related to asking the right question with the witness. Basically, they are related to something, a concept called the concept of leading questions. And we will try to answer three questions. First, what are leading questions, when they can be asked, and when they cannot be asked. So let us start. First is leading question. So section 141 defines leading question. It says any question suggesting the answer which the person putting it wishes or expects to receive is called a leading question. So, leading question is a question which has got inbuilt answers in it. The answer is inbuilt in the question itself. Like this question itself outlines what would be the answer as such. For example, if we ask a witness, where do you live? Now, this is an open ended question, it's not a leading question. But if we answer, if we question a witness, is it correct that you live in Patna? Then this is what is called a leading question, because the question with the answer which is expected from the witness is inbuilt in the question itself, that suggests him or expects him to answer that yes, he lives in Patna, or no, he does not live in Patna. Now, section 142 is very important, as it says when leading question must not be asked. So it says leading question must not, if objected to by the adverse party, be asked in examination in chief and re-examination. So basically this says that leading questions should not be asked in examination in chief or in re-examination, except certainly with the permission of court. And it further says that court shall permit leading question as to matters which are introductory in nature, undisputed, or which in its opinion has already been sufficiently proved. So, general rule is laid down that in examination in chief or in re-examination, no leading question can be asked. But the exceptions to it is that if the question is introductory in nature, or if it is undisputed, or it has already been sufficiently proved, then it can be even asked in examination in chief or re-examination. Now, what is the idea behind it? The idea behind it is that generally a witness, it is presumed that witness will be biased in favor of the party examining him and might thus be prompted. For example, if A is calling a witness, so certainly if A is calling a witness, a presumption would come in the mind that this witness will say in favor of A, and therefore if he is prompted by A to give a particular answer, certainly he will be giving it. So, in that case, therefore, section 142 has laid down that an examination in chief or in the re examination, leading question must not be asked. Now, in Varke Joseph versus State of Kerala, the Supreme Court laid down the basis or the idea behind it. It says that a fair trial of accused is not possible if leading questions are allowed, and it would be in violation with Article 21 of the Constitution, because then in that case the the witness will be prompted to speak against the accused, and he will be speaking against the accused. Then section 143, which says that when they may be asked. So 142 says that they cannot be asked in examination in chief and re-examination, and 143 says that when they may be asked, so they may be asked in cross examination. Now why? Because generally the purpose of cross examination is to test the accuracy, credibility and general reliability of witness. Now, through leading questions, one may be tested on these three criteria, that whether he is credible, or whether the witness is reliable, or whether what he is saying is accurate or not. Therefore, leading question may be asked in cross examination. Now, just to sum up that, when can leading questions be asked in examination in chief and re-examination? So in cross examination they can always be asked, but in examination in chief and re-examination they can be asked first when they are not objected to by the opposite party. So if A is asking a leading question from its own witness and the opposite party B is not objecting, then certainly it can be allowed. Or when they deal with the matters which is undisputed nature, or which is introductory in nature, or which has already been sufficiently proved, or and the fifth says that in cross examination they can always be asked. So this is all with section 141 to section 143. Let us just revise that section 141 defines leading question, that a question which has got built-in answer in it is a leading question. They can be asked in cross examination. They cannot be asked in examination in chief or in re-examination, except in certain circumstances, that if they are undisputed nature, or they are introductory in nature, or they have already been sufficiently proved, or they are not objected to. So that's all for today. Thank you, friends.